At long last, the 4-day carbon tax court reference at Osgoode Hall in downtown Toronto has come to an end. No decision's been rendered, of course, a lot of information for the 5 justices on Ontario's Court of Appeal to go through, but ultimately Ontarians and indeed all Canadians really have been able to see what the key arguments are here. The federal government has put forward the position that it doesn't just have the jurisdiction, but ultimately the obligation to act on reducing greenhouse gas emissions to curb climate change. The provincial government saying we don't disagree about the need to advance an aggressive policy, perhaps, to reduce greenhouse gas emissions to reduce climate change. However, it is the responsibility of the provinces and not the federal government to make that distinction. There were a lot of arguments put forward by both sides that really go down to some very key Supreme Court cases that talk about the enumeration of powers. And I'm not going to go through all of these, but I will say that it was interesting that a new dimension was added to the discussion on the 4th and final day of the hearing, and that was whether this can adequately be characterized as legislation acceptable under the emergency powers that the Constitution authorizes the federal government to do, irrespective of provincial powers. And I mentioned this briefly earlier in the week. The federal government did not make emergency powers a key part of its submission. It was actually the David Suzuki Foundation and the Intergenerational Climate Coalition that did, prompting almost a footnote from the federal government of, well, if the court agrees with that, then yes, we'll pursue that. And what I found so interesting was that despite how minimal the role of that discussion was earlier in the week, it actually occupied a pretty significant chunk of Ontario's closing arguments or replies today. So the question becomes, is that a potential source of frustration or hesitation from Ontario, that maybe that was a compelling argument put forward by the interveners? We don't know and won't know, but it was an observation that it seemed to get more airtime from the Ontario government than from the Canadian government. Among the other key questions are whether this would open the floodgates to federal government overreach into provincial territories. The federal government says no, it can be very limiting in its own legislation moving forward. The provincial government, not just in Ontario, but also in Saskatchewan and New Brunswick, says this could in fact cause monumental challenges for other provinces moving forward if they do not have the right to keep these areas in their jurisdiction. Among the many arguments that were brought up, we'll obviously follow this as it advances, and I'd note that the Manitoba government earlier this month said it would be launching its own legal challenge with the election of Jason Kenney and the UCP in Alberta. They may be launching their own challenge as well. So we are heading towards inevitably a Supreme Court case at some point. We're not there yet, but we'll of course follow this as things progress. For True North, I'm Andrew Lawton.